Well, hello there, ladies and gents. Great to see you again, and welcome back to Closing Arguments. Ryan Ruff here, your moderator, and as always, I'm going to be joined by the brains and the brawn of our show. That's Mr. John Razumich, or Jack Razumich, as many know him by. He's going to be tuning in from his offices at Razumich and Associates, and we're going to be jumping into another great season of content here on the podcast. I want to take a moment before we launch into everything and just express a big thank you to all of the audience members that have been both watching on YouTube or listening on the various podcasting platforms. You guys have just shown a real outpouring of love and support and interest, frankly, in these discussions that Jack and I have been bringing to the show, whether it be the deep dives into criminal law related topics and lessons, or some of the case studies that we've been covering, everything from the quirky, curious case of the hot dog man to, the state of Indiana versus Richard Allen, a really hot button topic and case that's been hitting the greater state of Indiana and really the country at large. So we very much appreciate that support, and we are so excited to be bringing you another season of great content just like that. Now, obviously, it's been a little bit since we've pumped out another episode here of Closing Arguments, and we have good reason. Jack and his team have been just absolutely pedal to the metal this last year, dealing with, I think it's almost double digits in jury trials and cases that they've been working on. I'm super excited to have Jack fill you in. So before we get into all the fun stuff that we have on tap for today, let's go ahead and say hi to the man of the hour. Jack, great to see you today. How you doing?
We're back. It's like we never left.
Exactly. Yeah. Never left, man. And Jack, you've, dare I say, been busy since then, right?
Everyone's been busy. It's been insane. We had a presidential election. We had Richard Allen's case got done. We were covering that for a while. As you pointed out, part of the reason that we've been gone is we've been busy. The show has gotten a lot more eyes on The Office. We've gotten a lot more contact as a result of that. And we just found ourselves in constant trial mode over the last year. 2024... even in 2025, we've been doing nothing but jury trials, constant jury trials. Time of recording, I have 2 jury trials set back to back over the next 2 weeks of September. That's how much we're doing with jury trials right now. We're somewhere between insane and a rarity in the legal field, I'm told by my colleagues. I don't know that I disagree with them on either of those things, but it's definitely been busy, and it's the good kind of busy, but that said, definitely feels good to be back here in the studio with you. Neither of our backgrounds have changed. Right. It's like everything is the same.
Yes, it's still a nose to the grindstone here on the show. And Jack, we thought it'd be fitting after what's been such a super busy year for you and your team and all those jury trials that you guys have been working on. What we wanted to do for today's episode was really what you've learned, some really key lessons and takeaways from what seemed to be really an entire year's worth of doing jury trials. There's a lot of nuggets of information and some wisdom that we, as you and I were kind of thinking about how we wanted to launch the show, we were like, hold on, there's a lot of good stuff in there in your experiences, that is, for our audience to take away and think about should they ever find themselves in a situation where they need representation. So we've got a few really big takeaways we want to share with everybody today. Why don't we start from that high level? I mentioned a moment ago, Jack, that you guys had almost double-digit cases last year, and of the ones that you did work through, there was a handful of sexual abuse cases that always come with really, sensitive but tricky manners, So why don't you set the scene there for us, and of course we'll work through some of those key lessons that you guys learned this past year.
Oh, way to go straight for the hot button ones.
Right.
no easing up into the big red button on that one. Just rip the Band-Aid right off. You are correct. A good chunk of the cases that we worked on in 2024 were sexual assault related cases, and those are difficult across the board for a lot of different reasons. They're difficult on the accusers. They're obviously difficult on the defendants. They're going to be difficult on us once we have to start moderating the comments for this episode. And they're difficult on the jurors. One of the things that we found during the process of doing those juries over the course of the year is that the evidence is I wouldn't say non-existent. But very frequently, these types of cases do heavily come down to the credibility of the accusation and the credibility of the denial. So, in none of the cases that we went to trial on in 2024 were there the traditional forensic evidence that people expect because of TV shows. Like there was not a single case that involved DNA evidence. There was not a single case that involved a smoking gun like text messages between the accuser and the accused. It was all credibility. One of the cases that we worked on, believe it or not, involved someone who was accusing her father of having sexually abused her almost 2 decades earlier. And one of the things that people don't understand is that there are different offenses, of course, have different statute of limitations. In the state of Indiana, if you are going to commence a prosecution for a allegation of child sex abuse, the prosecution has to be initiated before the minor victim turns 31. So it's a huge statute of limitations. And the problem is, you can imagine that you run into something like that is, I can't even think of what I was doing 20 years ago to be able to defend myself against an accusation like that. I could do what all of our clients did, which is deny the accusation, but the ability to come up with affirmative evidence to support that denial is very difficult. And that leads into the second major thing that we really found with dealing with those types of cases, which is that we say that all cases are innocent until proven guilty, and that is the general foundation. What we found doing these types of cases is that for the juries that we spoke with after the fact, the default was always no one would make this up. The default position of the jury was that if it made it to the trial, if someone had gone through the entire process of making the accusation, sticking with the accusation, appearing at trial to continue the accusation and make it under oath in front of them, it was clearly credible. Nothing that we were able to do. And we had a lot of practice trying different techniques to address credibility issues. Seemed to work. It was very heavily we didn't think there was any reason for them to make it up. And some of those cases were just aggravating to work on from the defense perspective. One of the cases that we worked on involved a teenage accuser that we had proof was looking up online how to never see her father again minutes before she made this accusation. It was part of an ongoing divorce custody dispute situation. Dad was in my opinion, at least as credible as his daughter was. He took the witness stand, maintained the eye contact, denied everything, went into the back and forth that he and his daughter's mother were having with regards to the custody situation. And after 8 hours of deliberations, it still didn't matter because there was no reason for her to make it up, is what the concept was.
Yeah.
And that was always a difficult thing to talk about with the defendants on it as well, because everyone has this idea that if it's just her word against his or his word against hers, they can't convict. And I 100% want to tell everyone listening that is not correct. If someone gets up on that witness stand and points the finger and says, I have been victimized by that individual, the only way that we have reliably found to really attack that accusation is you've got to provide some sort of motivation for the lie. And that's hard to do.
Yeah, that's a tall task for a defense. I mean, especially when you have the smoking gun, like you mentioned earlier, whether it's text messages, DNA evidence, it usually can be, well, I shouldn't say usually, it can become more of an open and closed situation where a jury can obviously anchor their opinion on physical evidence. And yeah, and as an uphill battle, to say the least, when that doesn't exist and you've got to, I think innately as human beings, we want to sympathize for a victim. We want to make sure that they feel heard and understood and seen, especially given the sensitive nature of a sex-related crime. But when you're looking at the defense side of things, it's a really tall task to be able to argue it when there's nothing physical to really bring to the table.
And it's a difficult thing too, and you know, there were a couple of prosecutors I went up against multiple times over the last year and a half at this point in time that both sides can now predictably adjust our arguments based off of knowing what the other side is going to say at this. And you know, it is true that these types of incidents aren't going to leave a lot of physical evidence, especially if they're not reported right away. It's equally true that, you know, if you claim that someone burgled your house, you're going to probably be able to point to like a broken window. So there's forensic evidence. There's something physical to point at. It's a very difficult line to have to walk. I agree with you. You do want people to feel heard. You do want to take these accusations seriously. But at the same time, we're not that far removed from the Salem witch trials as far as how we prosecute these cases. You know, we had... you know, back in the 1500s, we put 39 people to death based off of unsupported accusations, and we're not putting them to death anymore. But it's a problem. Mm-hmm. That's going to get negative comments. I know it already, but you know, the truth is the truth.
Yeah, when the historical evidence doesn't lie there. But Jack, this was one of the big takeaways from your team and working particularly these sex-related cases where you saw physical evidence and lack thereof creating such that challenging task for a defense to really argue their point, you know, regardless of whether or not they did or did not, perpetrate or go through the process of committing that crime. But there was another really big issue or really lesson, takeaway, however you want to classify it, that you and your team noticed over this past year. And it's all surrounding more or less the impetus of a trial itself. And that's the process of doing trials and taking crimes to trial. And you were telling me as we were sitting down getting ready for this episode, you know, Ryan, these trials they're starting to become almost a thing of the past. Share with our audience what you mean by that and how you kind of arrived at that conclusion over the past year, given what you guys have experienced.
Well, I think we talked about this in one of our earlier episodes too, about the history of jury trials and things of that nature. We've reached a point in American jurisprudence where the penalties for being convicted by a crime are so significant that the concept of going to trial is frankly terrifying, to be perfectly honest. Like even leaving like the non-sex stuff out of it, you know, that's terrifying on a different level. But let's just talk about a normal trial. One of the cases that we worked on last year that we did have a successful outcome on involved a domestic situation. It was one of those rare situations where the husband was the alleged victim and the wife was the defendant that we were on trial with. Her situation, she was charged with a level 5 felony for intimidation with a deadly weapon. If she had been convicted of that offense, she would have, there's obviously the base concept of you could face 1 to 6 years in the Department of Corrections. Given her previous criminal history in the place that we were trying that case, probably not likely, but that is technically a potential penalty. But they were offering her, a misdemeanor domestic battery offense. They were willing to dismiss the felony charges, and that's kind of one of those things, like that's a huge weighing concept on that. If you have the ability to not get a felony conviction, which those will absolutely ruin your life. Mm-hmm. Absolutely. Under current Indiana law, your best case scenario situation is that felony conviction is going to be on your record for 8 years before it's possible to look at expunging it. So that's 8 years of it popping up on job applications, on rental applications, on anywhere where anyone's doing a background check. In our current digital era where everyone's connected to everyone else these days, it ain't that hard to just do a background check, whether it's just a cheap Google search or going to a public court site. It's not hard to find these things. So, the concept of like not having that felony and not having that millstone around the neck, that's a scary process. And as you move further and further up the ladder, that gets worse. We were not necessarily connected with this show or today's show, but just looking at different issues with regards to the incarceration rate in the United States. The incarceration rate per 100,000 residents of the United States right now in 2025 is, I think it's 580 people are incarcerated for every 100,000 people living in the United States.
Wow.
That's huge.
Yeah.
And if you have the opportunity to avoid that, a lot of people jump at it. And that's why plea bargaining and plea agreements have become such a huge portion of the way that the judicial system works these days. And as a result, you are seeing fewer and fewer jury trials. The 9 that we did do in 2024, and we've done far less in 2025. There has not been a month that has gone by that we have not had at least one or more jury trials scheduled in any given month. But we have done far fewer of them in 2025 than we did in 2024. But of the 9 that we were scheduled to do in 2024, that's an insanely breakneck pace for private counsel. For the most part, private counsel does not do that. There are a lot of my colleagues that will see maybe one jury trial per year, if even that, and it's a rarity. The court-appointed attorneys frequently will, just because of sheer volume, try to move the cases as quickly as they can, getting them the best outcome they can, which again, like I said, there's a lot of charge bargaining that goes on with that. Like if you can avoid the most serious penalty by going to trial and winning, or you can avoid the most serious penalty by agreeing that you committed a lower level offense, that's frequently been the way to go about it. Now, is that trend starting to reverse? I don't know. I will say that what I have noticed over the past year is that prosecutors are becoming a little bit more intractable regarding what they're offering as far as plea agreements are concerned. One of the cases that we took to trial in January, we took to trial because the offer from the prosecutor was effectively the same offer that we would have received had we gone to trial and lost. So there's not an incentive to do that.
Sure.
If you're gonna be in the exact same spot, if you admit guilt and you get sentence X, but if you went to trial and were found guilty at trial, you still get sentence X. There's not a lot of incentive not to go at that point in time, because you'll preserve your appellate rights, you'll preserve your modification rights.
Right, and at least with trial, you have a fighting chance.
And there's a fighting chance. I will say, my general concept is always one of, you should not admit guilt to something that you're not guilty of. Don't admit you did something because you just don't want to do the trial, or you don't want to go and run those risks. Saying that you're guilty of something you didn't do is a very bad policy. So I've never told anyone to take a guilty plea if they did not believe themselves to be guilty. The flip side of that is, I have never told a person to take a case to trial if there was not something I thought that we could do for them. Every single one of the trials that we did in the last year, I genuinely believe that we absolutely had a solid argument to hang our hats on. There was not a single one of those trials that we did that I am not proud of the work that we put into it and the effort that we put into making sure that our clients got the best possible representation they could and had the best possible arguments were put out there. And I don't think a single one of those jury verdicts was less than 6 hours.
Wow.
We're giving them stuff to think about.
Yes, clearly.
I will say that I'm not sure that they didn't take that time to talk themselves into a verdict. It's kind of one of those things when you have your fifth, when you have your fifth or so 6-hour deliberation and they come back with guilty, you do kind of wonder sometimes, like, did you really take 6 hours to talk yourself into it? Because it really feels like you had to argue yourself into guilty if it took you that long. But that's just my own bias on
But to
that.
your greater point, where you're seeing, historically, plea bargains have just become a more prevalent thing. It saves the court system time and obviously money. It allows a potential win-win situation for you to plea, into a lesser, result of your, or lesser sentencing. Especially if we're talking about the felony situation, as you mentioned. That's a great point to bring up. I mean, if you're slapped with a felony, that the ripple effect is tremendous on what it can do to your life. So I hate to call that a win-win in the plea bargain, because you're still getting hit with at least some sort of sentence, but at the same time, maybe it's lesser to the point where it's not that tremendous ripple effect that you see. So it's no wonder that over time we've seen this drastic increase in the number of plea bargains. But Jack, there's a kind of a subset to the conversation here that you had brought up to me, and I want to make sure that we hit it before we end our episode today, and that is, when we're taking less to trial, the state or the prosecution doesn't necessarily need to, and these are my words, maybe necessarily need to bring their A game, because they know that most people don't even want to try the cases in the first place. They're looking for a plea agreement as they're approaching the table, rather than going to challenge the state. What are your thoughts on that?
I think it's a little bit of column A, a little bit of column B as far as that's concerned. I will say that the legal system, and again, this is the opinions of me personally. It's not necessarily the opinions of the State Bar of Indiana or anything along those lines. But my personal opinion, having worked in this system for close to 2 decades at this point in time, is that we have a legal system. We do not have a justice system. And the distinction that I make between the two on that is, the legal system is designed to execute the laws and carry out punishment, whereas a justice system would be designed to find solutions that led to rehabilitation. And because we have a legal system, everything that goes into it is designed to perpetuate itself. Right. For example, in the history of mass media, whether it was radio, television, movies, I won't say video games because I was contradicted on that one, but for the most part, all of the stuff that you see is told from the state's perspective. The state gets it right. The state gets the bad guy. The bad guy goes on trial. The bad guy gets convicted. It's all set up to kind of establish that there is a perpetuation of that. We have Perry Mason and Matlock. That's what we have on the defense side. Really, I can't think of very many other things where defense work or defense attorneys have been presented in a positive light. So you have a situation where we are constantly receiving this drumbeat of police procedurals, legal procedurals that if they've gotten to the point of trial, if they've been arrested, they must have done something wrong. Mm-hmm. There's not as much pushback on that as there probably should be. And I'm not saying that my clients are angels. I know what I do for a living. I know the people that I work with. A lot of them are, in fact, guilty of something. Frequently, even the stuff that they're on trial for. The issue is less the morality of that and more the concept of, have the rules been followed? And frequently, it does feel like the people who end up on the jury don't want to push back on that. Like, if the trial that we did in January of this year, which I know that we were talking about last year, but a year is a year, and all this time blends together at some point.
Sure.
It was a firearms case. It was a serious violent felon in possession of a firearm case. I don't think that the prosecutor failed to bring his A game. I think that the prosecutor who was handling the case, because of lack of experience with doing jury trials, was not as prepared for some of the curveballs that you get. One of the things that really became an issue with that case is police in Indiana, like just about everywhere else since 2020, have mandatory body cameras that they wear. And those body cameras are always recording. They turn on with a variety of different things. But that footage is supposed to be stored in a central depository someplace. Details on that aren't particularly important for these purposes. But it seemed like that footage for this particular arrest disappeared, and not through any malfeasance, not through anyone doing something untoward or anything along those lines. Like, stuff just happens sometimes. So both sides going into it, we as the defense were kind of making a big deal out of the concept of where's the footage? Why can't we see the footage? And the state conceded that the footage had disappeared. One of the police officers that testified that he had reviewed his body camera footage that morning before coming to trial. And you could hear the record scratch, you could hear the pin drop, and you could see the eyes of the jury just suddenly snap to attention. Mm-hmm. And that was a situation where, the prosecutor unfortunately just kind of got caught in the situation of, like, I was not prepared for the police to tell me that footage that we could not find was still in existence. And he kind of got caught off guard by that. And the jury didn't necessarily push back because the state had overcharged or the state had overreached. I think that was a situation of the jury properly, in my opinion, decided that they just did a really sloppy job. And that doesn't happen enough. There's not enough pushback, I think, from juries, and there's a little bit too much of acceptance of the idea that if you're on trial, you did something wrong. So that's a problem. But that kind of, to say that they don't have to bring their A game, we'll find out. One of the juries that I'm working on next week involves a case of a prosecutor who hasn't even spoken to his alleged victim, who hasn't provided certified medical records or subpoenaed any medical witnesses to come testify, which kind of makes getting medical records into evidence complicated. They don't have a sponsoring witness for the 911 call, and when they recovered the stolen vehicle that the shooting was over, they did not even make a token effort at processing it for fingerprints or DNA. That's not to say they're going to find anything, but failure to even put an effort into it, that comes across as really sloppy and really lazy. We'll see what happens. I have to be honest with you. It's still a coin toss as to whether or not that trial would be a successful defense or a successful prosecution. So from that perspective, maybe for a couple weeks I'll be ranting about how they don't even bother bringing their A game. But it is a situation where, because of societal expectations and the way that we have built things, it does seem like there is a little bit more of a practicing law in easy mode. Now, if there was a prosecutor sitting in my seat having this discussion, I'm sure they would have a completely different opinion.
Oh, of course. Of course they would.
And I have there are a few prosecutors I'm on good terms with, mostly ones from my own generation who are still at the prosecutor's office that we'll have the discussion over drinks about the worst parts of our job, and we can at least still get along, but we both have different perspectives over who's got it easier in the system. But it's my show, so they get to have it easier.
Fair point. But Jack, so as we kind of like bundle up the takeaways from this episode there's the jury's perception. That is always a tricky thing to navigate, especially when we're talking about sensitive crimes. In today's instance, we talked about a few sex-related cases that you had worked on. Navigating that jury's perception is a tall task, especially when it's sensitive in nature and you really don't have that smoking gun. But then as we moved a little further, we're talking about the process of doing trials, and of course what the state and really what the legal system as a whole has kind of shifted itself into this what feels almost like a cyclical process that might be, like you said, prosecuting on easy mode potentially. But all this to say, there's really only one person in your corner when you are charged with a crime, and that's your defense attorney. And whether or not you're negotiating a plea deal so that you're maybe not looking at that felony charge that's going to ruin your life and ruin the opportunities for future opportunities, or B, going to taking this thing to trial and having somebody, fight the fight with you. The legal system is not set up to help you without the help of a defense attorney. Jack, as we kind of wrap up today's episode, what say you to that claim?
I think that's 100% accurate. Trials are lonely, incredibly lonely. I know that from my perspective, the amount of work that we put into it, because you can't do this type of work if you don't care on some level. And there's all kinds of flippant remarks that we all make to kind of cope with the trauma, for lack of a better way of putting it, that we see on a daily basis. Like, we're never dealing with people at their best. Like, no one comes to my office or any criminal attorney's office because they're happy. No one calls me at Christmas offering me delicious gingerbread cookies. Everyone who comes here is hurt and is in trouble for one reason or another. And when these cases get to trial, one of the things that really bothers me more than anything is just how empty the courtroom is. If you're on trial and you have a family, tell them to come. Just sit out there and be some support. Like, I don't think that there's ever been a situation where, the presence of family members or a large group of friends made the jury sit and think, well, look at all those guys that are supporting this person. Mm-hmm. They must have, they must be a good person, and we'll do that. The state sometimes to their annoyance, let me be perfectly clear on this, their witnesses or the family members of victims or just interested people will frequently sit over there and stare daggers at the defendant or me or anyone that happens to be in there. I have actually seen people removed from the courtroom for making comments or making remarks or making faces during witness testimony or during cross-examination. So if you show up to support your family members, don't do that. Mm-hmm. But it is one of those things that, it appears from the optics that, one side has people that believe them and the other side doesn't. And that's terrible. I understand not wanting the people that you care about to sit there and listen to all these terrible things, or potentially hear that you've been found guilty and watch you get walked away in handcuffs. But you want more than just us. Obviously, you need your attorney there. We have to be there to stand up and make the arguments and do what we can to fight for you. But for God's sakes, have someone show up and support it. So yeah, it's that is. So frequently we're the only ones that are there, and that's not even just because we're the ones that are trying to make sure the state isn't running you over. It's just we're the only ones who care enough to show up, and frankly that's terrible. Like, that's not the way that it should be.
Mm-hmm. Well, I think that puts a really nice period on the end of today's episode. Jack, you said it yourself. Trial is a lonely place, and if anybody feels like they could use a lawyer that's ready to fight for them and stand in their corner and take on that challenge and representing them and helping to either get that plea deal or to flat out, get that conviction overturned, what would be the best way somebody could reach out to you and your team to, ask for that lifeline, to start that conversation and ultimately seek some representation from you guys?
As always, the best way of getting in contact with our office is by telephone. The main switchboard number here at the office is 317-983-5333. Someone's always going to answer that number, even if the main staff is not here at the time because it's after hours or what have you. That number's always going to get answered. That a message will always be taken by a live operator. It will always get to my attention or my senior staff's attention. And the call's free. Our case evaluations are still free. That has not changed over the last year. And we'd rather you talk to someone than not. And the final point I kind of want to make with regards to the importance of making that telephone call is when people get sick, they go to the doctor. They don't just shrug it off and say, oh, well, what happened, whatever, it doesn't matter. And people, I think, understand that no matter how good your doctor is, sometimes the patient still dies. Cancer's going to sometimes win, the organ transplant's not going to take, but people still go to the doctor. People still understand that it is important to do that. There's no giving up. There's no point in not doing that. Same thing with your legal defense. It is a true fact that no matter how well prepared we are sometimes our clients will still lose. They will still be convicted, and that sucks. It doesn't mean that you give up and don't do anything. You still need to pick up the phone. You still need to speak with a competent representative. You still need to at least put an effort into finding out what your rights are. If you just give up and you don't do anything because you think, what does it matter? I might lose anyway. Why should I spend this money? Why should I put this effort in? At that point in time, now the state really does have it on easy mode. If you're not going to fight for your rights and you're not going to take the effort of talking to someone to see what your rights are, then you've already lost. You gave up before you even had the chance to decide whether you wanted a jury trial. So, yeah, definitely make the call. Like, you're not wasting our time. We're literally here to answer these questions for you.
All right, Jack, I appreciate you. And folks, again, we had that phone number website at the bottom of the screen for you. Jack, appreciate you and your time as always. Really looking forward to diving into season 3 with you. I know we've got some great conversations here on tap for folks, and I'll see you back here on the next one.
Absolutely. Let's get in contact with Ground News. Maybe they're sponsoring everyone else. If they sponsor us, maybe we can get the show out a little bit more regularly without waiting for a year between seasons.
There we go. Look, folks, we want to take a final moment and just thank you again for the constant outpouring of great commentary, feedback, and of course, just general interest in the show. That's why we're able to sit here and bring you season 3. We've got a great season's worth of content coming to you with some interesting case studies, of course, some legal system facts and deep dives as we typically do on this show. And we are very, very much looking forward to sharing that information and those stories with you guys. But look, as always, if you enjoyed today's discussion, please make sure you hit that subscribe button on whichever platform you checked us out on today. It helps us a lot, and also make sure that you are regularly tuning in to each new episode that we drop. We would hate to have you miss out on any of the fun that's coming your way. So be sure to hit that subscribe button, and we'll see you back here on the next one. But for Jack, I'm Ryan. Again, we thank you one more time, and we appreciate each and every one of you stopping by and being a part of us today on Closing Arguments.